Well, good afternoon and welcome. My name is Gladys Cisneros. I'm the branch chief for labor migration at the International Labor Organization. I couldn't be more proud of the book that we are about to launch, our new book on temporary labor migration. So, why focus on this particular topic and why devote a book to this? Well, as many of you know, uh, the ILO has a constitutional mandate to work on migration, and the specific issue of temporary labor migration has long been a concern for policymakers and one that is very much likely to grow in demand. While temporary labor migration is often viewed as perhaps a strategy to alleviate poverty and foster development outcomes, the truth is that it still remains a thorny issue, and it can be associated with decent work deficits. Most forms of temporary labor migration actually remain a significant challenge for the protection of migrant workers and for the effective governance of labor migration across the world. In 2022, the ILO's governing body discussed temporary labor migration and acknowledged all of its complexities. The governing body also called for further investigation into the ways forward that could maximize opportunities and minimize the risks associated with temporary labor migration. This book is the reaction to this call. It emerges as a joint effort between the ILO departments of work quality and research. In fact, the decent work deficits experienced by many temporary migrants are well documented, but the advances in policy design to improve the situation of workers is actually less known. Therefore, this book provides new research on innovative policies in light of the many transformations that are shaping temporary movements of people today, such as protracted conflict, shifting production patterns, and the expansion of free trade agreements. This book also reflects on what we can learn from the past to make current programs more fair and to not repeat the same mistakes over and over again. The chapters of this book were written by an interdisciplinary group of experts. So we have a quite rich and novel analysis of the numerous dimensions that must be taken into account, including issues of economics, law, politics, sociology, geography, and so forth. Now, I'd like to speak just a little bit to frame this and introduce the book's structure. So this book has 4 parts, and we have the pleasure to have each of the chapter authors here today who will sort of represent each of the parts. Part 1 is all about transient categories, shifting paradigms, and their policy implications. It calls for greater awareness of the limitations of definitions and better understanding of their transience. We always have to keep in mind that there is no universal definition of what makes temporary labor migration. And we will hear about shifting paradigms on temporary labor migration, for instance, in global debates, from our colleague Richard Cholovinsky here, who's joining us today. Thank you so much, Richard. It's really nice to see you. Part 2 of this book incorporates emerging areas that impact labor migration governance, such as international trade, the growth of mobility programs, and the complexities of forced migration and mixed flows. The chapters within Part 2 speak to these newer developments, and they reflect on the implications on the protections of people who work abroad temporarily, but who are not currently classified as labor migrants or as migrant workers, migrants for employment per se. Business migrants are a group within this category, and it's my pleasure to welcome today Paula Hofmeier-Zlotnick, one of the co-authors of a chapter in Part 2 that questions business mobility as a privileged form of temporary labor migration. How to better protect temporary labor migrants is the central question for the authors of Part 3. Although they examine quite different measures of protection. We have 2 chapter authors who are joining us today. Our colleague Natalia Popova will address policy coherence and the involvement of social partners in migration policymaking. And Daniel Costa, who will speak to the political sensitivity of the issue of untying workers from employers, which is also called visa portability. Thank you both for being here today and for enlightening us on some of these urgent questions. And finally, part 4 takes a longer-term view on temporary labor migration. And this one is more about learning from the past to prepare for the future, using Australia and Switzerland as key case studies. In addition, our colleague Aurelia Segatti presents ideas to this effect in relation to North African temporary labor migration to Europe. And she will share, she's also here with us to share today. Thank you so much, Aurelia. But let me now pass the floor to our 2 editors of this book, our colleagues Cristiane Kupst and Fabiola Mieres, for some remarks about the contributions that this book makes, some of the key takeaways, and further reflections about the future. Please let me yield the floor, and congratulations for this publication.
Thank you very much, Gladys, and a very warm welcome from my side as well to everybody in the room and everybody online. Now, how does this book contribute to ongoing debates on the regulation of labor migration? At the current juncture, there are many discussions, as many of you will know, about expanding legal pathways for migrant workers as a means to reduce irregular migration, notably. And some of the temporary labor migration programs are being considered as a way of achieving this. However, given the vast evidence that we do have of potential exclusion from labor protections and also the lack of integration in host societies, it's very important to critically reflect on what avenues would be most effective to achieve viable solutions. And that is exactly what our authors do. There's also, as a further contribution, the issue of how to strike a fair balance between different interests in the design of programs. And this book illuminates the standpoints of migrants, of employers, of policymakers from both origin and destination countries, and it provides fresh reflections on the many dimensions that need to be taken into account, particularly because the regulation of migration lies at the intersection of law, of politics, of economics, of social developments, and even many other factors. And a further point, the global architecture of migration governance is constantly under review, as evidenced in the reviews that are being carried out in the framework of the Global Compact for Safe, Orderly, and Regular Migration. And this book provides an in-depth exploration of the different categories of temporary forms of migration and mobility, and at the same time, the regulatory efforts to protect human and labor rights, and also looks at how all this links to labor market and societies. And for some of the takeaways, do you start, Fabiola?
Thank you. Well, first, I would like to thank Gladys and where I sit now, the research department, for all the support to do this work, but most importantly to all the authors and the colleagues who have peer reviewed the work, this very important aspect. So I think there are a lot of takeaways from this book, so I would encourage everyone to read it, actually, and we're very lucky today to have some of the authors presenting some of their own findings. So I won't take too long, but probably I will just share some of the features that I found particularly interesting in embarking in this research. And probably one of them is that in temporary labor migration, we see a lot of different manifestations, different forms, and some of them are even presented as novel or newer forms. But actually, when we really look at the labor market dimensions of these programs, we find that they're actually not that new. And actually, they resemble past guest worker programs, and they are really issues and another manifestation of precarious work and insecure work. So this is really calling our attention from a regulatory perspective, as we do work in the ILO, of whether some of these models is, for instance, we explore the case of Canada, thanks to Leah Bosco in our book, but there are the contexts in which this is happening. So I think I would say that's one of the main takeaways of the book. And also, in looking at the evolution of these programs, we see a consistent and persistent structural demand for migrant workers in particular sectors. And this is something that the ILO has been calling on for more than 100 years. And we continue seeing it in particular sectors such as agriculture, hospitality, the care economy, our colleagues working on these issues. And why is that? I mean, we have a lot of different reasons and root causes analysis for this, but temporary labor migration programs are sometimes presented as a way to resolve this, and under what conditions and what cost. And I think the book does really well in showing the problematics around this. And finally, I would say that it's not all doom and gloom, as there are a lot of decent work deficits in these programs, but we have some innovations. We have to document cases of regulatory reform in the governance of migration, where actually we are making progress in what we will hear untying workers from their employers, the so-called visa portability, or also embedding notions of fairness and social dialogue, so key to the work of the ILO, in, for instance, the review of the Australia case. In the context of Australia, the historical, political, and cultural concept of the fair go, that is that everyone has to participate in society in a good way or given a good chances, reading about this concept and learning that it has a lot of different dimensions. So I wouldn't go into that today. But these principles have been embedded in the Australian review, actually also founded on the fair migration agenda of the ILO to bring about change. So I would say these are some of the takeaways. I would love the audience to keep with them.
Yes, and I would like to add two more, which we both think are very important. Number one, protective tools might sometimes look very, very good on paper, but implementation is what really matters. We have one of the book chapters here, which will not be presented today, but for instance, that highlights how the signing of bilateral labor agreements alone does not guarantee the protection of labor rights and therefore does not change the rights or the lives of migrant workers, right? What really matters in that particular context is more monitoring mechanisms and obviously political will. Number two, as long as immigration law, and I'd like to hammer down this point, as long as immigration law dominates labor law, it will be very, very difficult, if not impossible, to create a level playing field between migrant and local workers on the one hand, and between employers who have access or who don't have access to migrant workers on the other hand. And we will not arrive at fair outcomes for all under those conditions. For example, when minimum wages under temporary labor migration programs are different from local minimum wages, it's absolutely impossible to achieve equality between temporary labor migrants and the local labor force. And
yes, I guess before we move on to the real important part of the day, who are the authors, I would like to just say that at the end, we provide some early reflections on what do all these different cases and studies mean for social justice of migrant workers. And here is where I think we lie between some skeptics who say, well, the principles of temporary labor migration and social justice cannot be reconciled because of all these abuses that have been documented, all the things that we know. But on the other hand, there are others that say they provide labor market opportunities for migrant workers, actually enhancing global welfare. So we should try to explore pathways for temporary migrants. We lie between this tension. The book tries with the different cases to provide an analysis of why this is the case, taking into account that social justice, of course, is not a given for migrant workers, but we can work towards untying different particular aspects of the program so that this can become a reality for the migrant workers. And I guess, yes, it's now time to move to our speakers. So I have the job, the very unpleasant job, of being the timekeeper for Ryszard Czerwiński and Paula Hofmeier-Zlotnik, who will guide us through their findings, and then we will open the space for questions. And without further ado, Ryszard, I see you there. Welcome, and the floor is all yours.
Thank you very much, Paula and Christiane, and thank you also Gladys, for the earlier introduction, and greetings from Beirut. I'm just a quick question of technical question. Fabiola, is there anyone that can move my slides, my PowerPoint there, or?
Yes.
Okay, thank you. I think it'll be easier if it's done from your end.
Yes.
Okay, so my chapter in the book, in part one of the book, has a very long title: Back to the Future, Temporary Labour Migration, International Standards, Global Policy Dialogues on Migration Governance, and Global Compact on Migration. And so let me unpack this a little bit for you, and if we can have the next slide, please. So essentially what this chapter looks at is at the temporary labour migration paradigm in the context of international legal frameworks relating to migrants and migrant workers. So the reference here is mainly ILO standards, but also human rights standards, as well as the global policy dialogue on migration governance, both within the UN and at the ILO. And the chapter also looks at some of the policy positions in these debates that have been taken by non-governmental stakeholders. Of course, our social partners, workers and employers organizations, but also global civil society coalitions. And finally, the chapter examines temporary labor migration in the context of the Global Compact for Safe, Orderly and Regular Migration, or the GCM for short, which Christiane mentioned in her introductory remarks. This is a non-binding, cooperative global framework on migration governance that was adopted by the UN General Assembly in 2018, and many member states voted in favor of the compact. So on to the next slide, please. Okay, so temporary labour migration, international or legal frameworks. Next slide. And when we look at the international legal framework as focusing on international ILO labor standards as well as human rights standards, what are the key points here? Well, first of all, we're looking at fundamental principles and rights of work, and particularly equality and non-discrimination in employment between all migrant workers and nationals. And of course, the relevant ILO standards here are those relating to the technical conventions are those on migrant workers, but there are also other relevant standards, for example, the Domestic Workers Convention, the Private Employment Agencies Convention, and there are others, of course. And when we look at international human rights, again, we're looking at the core instruments and focusing very much on the application of the equality and non-discrimination principle. And here, a particularly important core instrument, of course, is the UN Convention on Migrant Workers of 1990. Next slide, please. Now, I don't have the time to go into the details of all the findings, and of course, I encourage interested colleagues to read the chapter in the book on this. But when we look at these frameworks, in principle, we find that they apply to all migrant workers, irrespective of whether they have come to a country to work on either a temporary or permanent basis. And here, importantly, the frameworks do not afford migrant workers more privileged or favorable treatment on the basis of their skill level. And this is an important point because this is not reflected much in national practice. And of course, many migrants that come for temporary work, not all, but many of them are in the sort of low wage, low skilled categories. Importantly, also, when we look at these frameworks, we see that there are few distinctions between temporary and permanent migrants. And this is particularly the case when we look at ILO standards. There are some, but there are not many. And also, the frameworks do not interfere with the sovereign prerogative of states to determine their own immigration policies on admission of migrant workers. So whether those states wish to admit migrants permanently or on a temporary basis, this is up to them. It's their sovereign prerogative to do so. However, consideration is given in some of these standards to enable temporary workers to switch to more secure status. Next slide. And in this part of the book, of the chapter, I look at the global dialogues and how temporary labor migration features in these dialogues, both at the UN, broader UN international level, and the ILO tripartite discussions. So starting with global dialogues on migration governance, and it's worth spending a little bit of time on this, there have been a number of initiatives. Again, I can't go into detail. They're depicted on this slide. However, the starting point is very much in what was called the GCIM report, it was a Global Commission on International Migration, which reported in 2005. And this commission really set the ground for the recognition of temporary and circular migration. And this relates a little bit to what Gladys said in her introduction, seeing temporary and circular migration as an important tool for promoting development in countries of origin. And this line was pursued subsequently in many of the other global debates that are featured on this slide. However, what's important and often is forgotten in these other debates is that the Global Commission also drew particular attention to the need to carefully design temporary migration programs on the basis of social dialogue to ensure labor protections, and also the Commission noted the continued relevance of permanent migration. Unfortunately, this really wasn't followed up in the many of the global debates that followed. The high-level dialogues on migration and development really focused very much on temporary migration, even though in their outcomes they did not really discuss temporary migration that much, with the exception of looking at circular migration of highly skilled migrant workers. In the Global Forum Migration and Development, the GFMD, which took place outside of the UN system, the focus was very much on temporary labor migration and circular migration as tools for enhancing development. And finally, in the New York Declaration for Refugees and Migrants, which was the outcome of the UN Summit for Refugees and Migrants, again, temporary migration was not referenced in the declaration specifically, only circular migration. However, that declaration did pave the way for the Global Compact. And in the annex to the declaration, there are references to several elements in the Global Compact which included, for example, promotion of labor mobility, including circular migration. Next slide, please. Again, I don't have time to go into detail of all the ILO tripartite policy discussions, whether at the IOC, the GB, the governing body, or indeed in a tripartite meeting. But to summarize very quickly, given the outcomes of ILO tripartite policy discussions, it's not surprising, of course, that these outcomes focus very much on the International Labour Standards Framework. And I think their principal contribution was to instill these rights-based elements into the global dialogue by either by emphasizing, for example, the important role of social dialogue and working to sort of, if you like, counteract the instrumental treatment of migrant workers in the migration and development debates, which is very much in line with the important ILO constitutional principle that labor is not a commodity. And these discussions in the ILO also influence the wider policy debates, whether also relating to temporary labor migration, whether through the interventions of ILO officials or ILO's tripartite constituents. Next slide, please. Non-governmental stakeholders, including employer and worker representatives, as well as broader civil society, have taken specific positions in these debates. So when we look at the positions of trade unions, it's perhaps not surprising that they have been concerned that such programs should not be used to fill jobs that are permanent. They obviously have been concerned about the limited rights protections in temporary labor migration programs, and particularly when it comes to freedom of association. And they have seen temporary labor migration programs as exacerbating the social and economic costs of migration, as well as its engendered impact, particularly in those sectors of the economy that are dominated by women. And we've already had a reference to the care economy in this regard. The position of workers resonates very much with that of civil society, which have actually called for the elimination of temporary labor migration programs that are seen as systematically exploitative. When we look at employer concerns, they mainly focus on the need of governments to consult employers on skill needs when it comes to designing temporary labor migration programs. Employers want predictable and efficient immigration processing systems, and they also want flexible laws to meet evolving business needs, including admitting foreign nationals for short-term assignments. However, there is some synergy between employees and workers, with the fact that employers also take the view that there is a need for migrant workers to come to fill permanent jobs. And so we should not, assume that there is always a divide by workers and employers when it comes to the design of temporary labor migration programs. And finally, the next slide, please. And this is the final slide. Christiane mentioned in her introduction the Global Compact. Next slide, please. Which also you'll see in that last bullet point regarding GCM Objective 5, which talks about regular pathways. And interestingly there, labor mobility schemes are defined not as only those schemes for temporary work, but also for permanent work. And long-term or more permanent migration also features in GCM Objective 22, which relates to access to social protection and portability of social security schemes. And so I think, and I don't have time to go into details on the GCM, but it's clear here that this temporary labor migration paradigm has not been as influential in shaping these commitments agreed under the Global Compact on Migration, which to some extent does go back to the future because it also references permanent migration, which was very much a feature also of the Global Commission's report in 2005. So just a few remarks in conclusion, if I may. When we look at the international legal framework, we should note that it does not view labor migration as purely as a temporary phenomenon. So workers admitted permanently, provided, of course, they don't take up citizenship of a country, as well as those admitted on a temporary basis, by and large, should be treated equally. When we look at the global discussions on migration governance, we saw that the discussions on migration and development focus by and large on the development gains that such programs could bring in terms of remittances and skills. However, this created a tension between, ILO constitutional principles that I referred to earlier, such as that labor is not a commodity, because they were seen in some quarters as viewing migrant workers in an instrumental way. But when we now look at the Global Compact on Migration, which is the broadest governance framework, even though it's non-binding on migration, we see now a return to perhaps a more holistic view of migration, looking both at temporary and permanent migration in the context of promoting regular pathways. So I'll stop there. That's just an overview of the core, if you like, elements of my chapter in the book. Thank you.
Thank you very much, Rishabh. I'm sure there will be more space for elaboration in the Q&A. So thank you for bringing and taking the time to document the evolution of these debates, which is very important, not only conceptually, but also for policy work. And now we pass the floor to Paula, who is going to take us on another important dimension of the global political economy, referring to international trade. Thank you, Paula.
Yes, thank you very much, Fabiola, and thanks to also Christiane for organizing. I'm very happy to be here and to discuss with you some findings of our chapter, which focuses on a very specific aspect of temporary labor migration that is, we argue, often overlooked, or that maybe people don't imagine when they think about temporary labor migrants, and that is what we call business migration. So maybe you can skip to the next slide, but I should say that, of course, this is co-authored with Sandra Lavenay, Mariana Alvarado, and Philipp Lutz, this chapter, and conceptualized very much at the University of Geneva, very close by, even though the slides are from the University of Cologne. So, as I said, the discussions around temporary labor migration and also the implications for migrant rights, they often focus sort of either explicitly or implicitly on a migration into low-skilled work. And what we're interested in here is looking also at sort of the other end of the spectrum and how temporary labor migration is intertwined with trade law and what that means for migrant rights. And more specifically, we look at business migrants. This is a term that we sort of coined to talk about migrants that go to another country to work. So they're labor migrants in that sense, but they actually don't have an employment relationship in the host country. So this is what makes them sort of special, and they often then also evade sort of protections for migrants, for labor migrants. And these are often intra-corporate transferees, so they're sent within multinational companies, or they are sent to work on a specific project for a client in another country. So by nature, their stay is temporary because it's tied sometimes to a specific project, but sometimes also just to the presence of an international company. And sort of how temporary their stay is can vary quite strongly, from sometimes only a few days to really several years, where there's quite close resemblance to quote-unquote regular temporary labor migrants. What's specific about business migrants is that the admission is facilitated in international trade law. So as Richard was pointing out, right, most international conventions do not interfere with state sovereignty to decide over the admission of immigrants, but this is different in international trade law. So please, next slide, which lines this out a bit. Most prominently, this is laid out in the General Agreement on Trade in Services, so the WTO's Service Trade Agreement, where the temporary migration, although it is not called migration, to another country for sort of this specific project is one of the four modes of delivering a service across borders. So the GATS was the first sort of multilateral agreement on this, but similar provisions had been emerging already before, and this is something that we've documented with my co-authors in the MITA dataset, the Migration and Trade Agreements dataset. And what you can see here is that this has started before, but then really exploded after the GATS was concluded, so in the 1990s and 2000s. And today, almost 80% of trade agreements, bilateral trade agreements worldwide, contain some form of Mode 4 clause, so they facilitate business migration in some form. Trade agreements also go beyond business migration, or some do, by containing clauses on migrant rights. This is often the case in EU association agreements, for example, and migration control. But these two have proliferated to a much smaller degree, as you can see on the right graph here, which shows sort of the number of PTAs of trade agreements that contain either of these three categories. So you can really see that mobility provisions have gone up quite substantially since the 1990s, and this has not stopped with recent trade agreements. The most frequent categories of business migrants that we see in these trade agreements are ICTs, intra-corporate transferees. And we often imagine them as really high-level managers of companies that go for specific projects, but they also encompass specialists. So these have to be highly skilled migrants, but they can be, for example, IT specialists working in a company. And this is, at least in the European context, also the great majority of ICTs. And then contractual service suppliers who were sent to fulfill a specific service contract. And this can be across the skills spectrum, of course, as well. And then trade agreements also regulate business visitors and individual independent professionals to some degree, but they're a bit out of this sort of employee framework. What do these trade agreements contain? As I already said, they're commitments on the admission. So countries commit themselves to admit these business migrants for a certain amount of time. And for ICTs, this is often several years. In many Swiss agreements, it's 5 years, for example. And they make the admission of these migrants easier by, for example, exempting them from labor market or priority tests. And sometimes there's additional facilitation, such as for the visa issuing, for recognizing qualifications, etc. So while the admission of business migrants is often easier compared to other labor migrants in countries, there's also, we argue, quite some room for commodification and rights implications. And this is what we elaborate on the next slide. So please, if you could switch. Thank you. So as I said, the core of business migration is that migrants are what we call workers without footprint in the country where they work, because they keep the work contract in the home country with the multinational company or the company providing the service. And so officially, they actually never enter the host country's labor market. And of course, this poses structural risks for migrant rights, even in this highly skilled and what some consider more privileged sector. So first, the very fact of moving to a country, right, is a corollary of an investment decision of a multinational company, or sometimes, and there's sort of increasing anecdotal evidence of this, also of, for example, outsourcing practices. And I'm very excited to hear Daniel Costa maybe talk more about this in the US context as well, where ICTs can be used to sort of migrate within multinational companies to a place where wages are traditionally higher, or would be more expensive to hire local workers than to import and do outsourcing through import. And happy to talk more about it in the Q&A. So this is one risk. And of course, in these schemes, what also happens is that similar to guest worker programs, in a way, the employer is even more empowered over the employee, because typically changing employers is not possible in these programs, given that they're really tied to a specific project or a company. So this is a difference often also to regular labor migrants. And there is some potential for unequal treatment in comparison to locally hired employees. And this is what's really tricky for this category, is that sort of business migrants can be both more privileged and more disadvantaged than locally hired employees, right? Sometimes these are managers coming with big compensation packages, and sometimes it is, for example, IT specialists coming from countries with lower wages that then sort of compete with local workers. Next slide, please. So in our research, we looked a bit at the Swiss context to see how big this phenomenon actually is. Because when we speak about these topics, or when also scholars talk about mode 4 type business migration, the argument is often, well, this is not really migration because they don't enter the labor market, but also that is a very small group that's not really worth talking about. And it's very difficult to actually know how many of these business migrants we have in practice, because countries have very different practices of collecting data, and most do not differentiate between different forms of migration. Maybe if you can click, there should be a sort of an increment. Yeah, perfect. So from other research, we know, for example, that in the UK, but also in the US, they are quite, the number of business migrants is quite substantial, where in the UK, in sort of the early 2000s until quite recently, business migrants or intra-corporate transferees accounted for between 30 and 60% of all work permits issued to non-EU citizens, right? It's obviously pre-Brexit. And Huang has numbers for the US that show that out of the temporary work visas issued to highly skilled migrants, so out of a specific category, right, then 27% are what are called L1, so intra-company transfer visas, so also quite substantial. And we looked into Switzerland and found that it's actually quite similar, and as you can see on the graph here, where we have data since 2015, because only since then the Swiss migration statistics distinguish between what they call posted or not posted migration, so whether a person comes with a labor contract from the home country. And here we can see that, again, between 1/3 and almost half of the work permits issued to, again, non-EU or EFTA labor migrants in Switzerland are going to these posted migrants or to business migrants. Next slide, please, or click, please. So this is also quite a substantial number for Switzerland. And of course, it would be great to have data for more countries as well. If you could click one more time, I hope then oh, I'm sorry that it's all, you can just click, yeah, perfect. So we looked a bit into Switzerland just to illustrate this. So the Swiss framework for immigration is generally regarded as quite strict, but there are a number of facilitations for migrants who linked to international postings. So for firms, it's actually often easier to hire migrants in this form than to hire labor migrants sort of in the regular procedure. And we have some statistics on also the characteristics of these migrants. I thought this would also be interesting to mention. So the top 3 nationalities are India, and India is by far sort of the most important country of origin, followed by the US and China. Yeah, showing sort of, I think, interesting global developments here too. The great majority of business migrants has tertiary education. This is not surprising, given that the focus is often on specialists and managers, and they do on average stay shorter than regular labor migrants, also something that we would expect, right? But in a survey that colleagues of us conducted with the sort of migrant population in Switzerland overall, and where they identified business migrants, a plurality of them said that they would like to stay longer than their initial assignment. So on the individual level, there is often sort of motives that are quite similar to other labor migrants, where they don't necessarily conceive of themselves as expats without footprints, but would like to stay longer. And of course, this is something that is made very difficult by often the regulatory frameworks for business migrants. Next slide, please. This already brings me to the conclusion. So what we wanted to show in this chapter is that business migration, as this very specific but quite substantial form of labor migration, is often overlooked in debates about temporary migration. And we think it is fruitful to not only acknowledge its existence and also substantial importance, at least where we have some data, but also as a result to sort of maybe differentiate the discussion a bit on highly skilled migration and yeah, disaggregate more of who we speak about and also think about the rights implications, because the legal setup of business migration does create these structural risks that I was talking about, of commodification, unequal treatment, and also unequal working conditions. So with that, thank you very much for your attention, and I very much look forward to the Q&A.
Thank you very much, Paula. That was very comprehensive as well. And so looking at the time, we have a few minutes for some questions or clarifying questions as well, or reflections. I would like to give the floor to people in the room first, and those online. I have some questions here as well, but let's see if anyone has a question in the room. Yes, please go ahead, Dagmar.
That me? Okay.
Yes, thank you.
Yeah, thank you so much for these interesting presentations already starting off. And congratulations again on the book altogether. It's really interesting and insightful. Richard, I think, yeah, we have been in touch, you know, when I was in South Asia and our collaboration with the region you're in. But I was wanting to ask you a question about the GCM. If you have seen any effects since that kind of came into force, the Global Compact, on countries' legal frameworks, so to say, influencing it to the better. And also, if you've seen any influence in terms of, international discussions, be it at regional level or cross-regional level, and I thought a bit of that impact that you might have been able to see, and what kind of improvements it might have brought about. And then I was interested, Paula, in your presentation in relation to business migration. Is there a kind of time limit that countries impose on these lengths of stay? You also mentioned that, there seems to be quite a few who would like to stay longer than their businesses actually post them. But I was just curious about if there is a time limit, and maybe comparing it to non-business migration, so to say, in terms of short-term migration or temporary migration. Thanks.
Thank you, Dagmar. So I would like to give the floor first to Rishab and then to Paula.
Thank you, Dagmar, for that question on the GCM. Obviously, we have colleagues in headquarters that follow the GCM, from the global level, and can also offer their perspective. But let me just offer a perspective from the region I'm in, which is the Arab states. And of course, when it comes to GCM, even though it's very comprehensive, there's a lot of good things in it. It is a non-binding framework, so that's important to emphasize. Even though it is supposed to rest on international law, and human rights are supposed to be an important guiding principle of the GCM. The commitments that are expressed in it are not the same. They're more political. They're not the same as legally binding commitments, for example, in ILO or UN human rights conventions. Having said that, though, when it comes to impact, of course, the GCM only really makes sense if it's implemented at the national level. And when it comes to our region, there's very little evidence of the use of the GCM in the formulation of, for example, national policies or legislative frameworks relating to, migrant workers. One of the exceptions, I guess, would be Iraq, because Iraq presents itself as what's called a GCM champion country, and has developed a national framework or policy on migration that draws on the GCM. And of course, there's a push for there to be national action plans or frameworks to implement the GCM at the national level. But the only one in the country that I cover that's sort of close to this is Iraq. Whereas the other countries in the region, even though they all endorsed the GCM when it was adopted in 2018, there's not much evidence of its use at the national level. So I'll stop there. Thank you.
Thank you. Yes, Paula.
Yeah, thank you very much for the question on the time limit for business migrants. So this really depends on the country, because even on the GATS, on the multilateral level, states have individual schedules where they sort of put down their commitment, and it's different also between contractual service suppliers, where often the stay is really limited to 90 days. So these are really short-term stays, and intracorporate transferees, where, I don't know, I don't have a global picture, but for example, the EU has committed 3 years, and it usually does so in its bilateral agreements as well. And the EU also has a directive now, so that sort of applies to all EU member states, where the length of stay is also 3 years. Switzerland usually has 5 years, if I'm not mistaken, 4 or 5. And we also looked at this for Singapore, which, if I'm not mistaken, has longer stays even in its trade agreement. So they can be quite long, especially for intra-corporate transferees, but it really depends on the country. And then, I mean, from what we know from the Swiss context, we know that indeed business migrants also stay for shorter amounts of time, like they leave the country earlier based on migration statistics. And this is not surprising, given that there is limits to not only in immigration law, by the way, but also social security and employment law. So the Swiss law, for example, allows for these business migrants to stay outside the Swiss social security system for, I think, 4 or 5 years. And after that, they would have to be treated as regular migrants. Nonetheless, I think what's interesting is not only that many migrants actually would like to stay longer if they're coming under these schemes, but that also many countries are actually interested in attracting highly skilled immigrants, often also for longer terms, right? So there is a certain tension often between the stated intention of these policies and the short-term nature, right? And the EU ICT directives also, for example, requires or allows member states to require a cooling off period so that these sort of missions of ICTs cannot just be extended forever. But many countries then allow ICTs to transition to more permanent status. This is obviously something that is then purely in the national immigration law framework. But for example, Germany does this and does it also explicitly as a way of attracting labor migrants. So I think this brings interesting implications here as well. Yeah, I hope that answers the question a little bit.
Mm-hmm. Thank you. We also have Jane who has a question.
Thank you and congratulations on the book, much needed research on temporary labour migration. I'm Jane Hodges, from an associate in the Global Migration Policy Associates, and in the interests of disclosure, former ILO official for 35 years. What interests me, and I'm looking forward to the next presentation of chapters, is the what's already striking me from the conflict of laws point of view. So we all know the situation, how we want to have firewalls between migration law, homeland security regulations and labour law. But I'm wondering whether Paula could explain a bit more, perhaps it'll come later on, when the business migrants have a problem, where are their conflicts settled? Do they have a choice of forum to go to? Is it only set out in their individual employment contracts, or is it within the bigger temporary labour migration scheme? In fact, that's the heart of the question. Are these business migrants actually counted within schemes where they do exist? Well, obviously, Paula's given the example of the MITA data set in Switzerland. But I go to that because there has been a lot written, back to the future, in the ILO about conflicts in employment relationships and how the difficulty of having clarity equally for the employer. So it's not just for the workers who claim to have their rights violated in some way, but the employers likewise want to have clarity on where conflicts are going to be settled. The other small point I'm looking forward to hearing on chapter 4, because when I did retire from the ILO, I returned to Australia, the temporary labour migration capital at the moment. And it was amazing to live and see so many people who've retired to country places and are running farms, or you might call them gentlewoman farms or whatever, but it's a booming industry for baby boomers. There's a lot of money in it. And the temporary migration schemes that have run through Australia, I'm looking forward to hearing your assessment of them. Thank you.
Thank you, Jane. Paula, if you want to answer, a few minutes.
Yes, I can try, but I should say that I'm not a lawyer or labor lawyer, so I'm afraid you might know much more than me about that. But I mean, it's obviously a very relevant question. So what we know from the Swiss case, but I guess that also applies in other cases, that business migrants do not become part of the social security system, right? That's a bit different from what you asked. So they often have sort of health insurance locally, but then pension contributions, etc., all stay within the country of origin. And when it comes to taxes, often there's a certain choice that employers can make. And I'm actually not sure, or I think it would differ on the national level, what exactly happens in the case of labor disputes. And this is something that also on the EU level, I think remains sort of an unsettled question. But the heart of these schemes, right, and the reason why they have privileges is that they have the contract privileges in admission, I should say, that they have the contract with the firm in the country of origin, and so the formal employer will always be in the country of origin. And of course, this can lead to all sorts of tensions when sort of the person actually giving the work instructions is set within the host country. But unfortunately, I don't have more sort of info from the ground, as our research is much more sort of on the statistics and the legal framework. So I'm sorry for that, but it would be super interesting to go deeper into it.
Thank you, Paula. So thank you for your interest in the Australia case. I think what's interesting in this chapter, and what we learned a lot from the experience, the chapter, what it does is goes over the review, because the author was one of the key leaders of the review, together with two other scholars, and they published a report, and they actually go into the assessment of the long history of how Australia moved from an immigration country to a temporary labor migration country, and then also with other types of visas like working holidaymakers, backpackers, all these different forms that in other countries we don't see, taking the shape of temporary migrants. And they take all of that together and assess what is fair in this and how it can actually respond to the labor market needs, what is not working in our immigration system that is highly based on temporary migration. So the chapter goes over the different interactions with the social partners, which I think for the ILO standpoint, that's very interesting, not just the workers, but also the employers. And it looks at what is novel, but what it adds is this idea of fair labor market outcomes. And I think that's why I mentioned the fair go notion at the beginning, because it really opened a conversation in that context on what constitutes fairness when it comes to distributional outcomes, when it comes to the working conditions of these people, how they're recognized. And without trying to summarize the whole chapter, fortunately, we can do another session on that one. I just wanted to say that it's worth a read, because it touches upon some of the issues that you were asking. So I would like to thank the two presenters of this session. We have a few more questions here, but we're going to park them for now and move on to the next, so we can have probably a bit of a wrap-up and other follow-up questions if necessary. So thank you, Paula and Rishab, and stay tuned for the next speakers. Christiane, the floor is yours.
Yes, thank you very much. So we are already moving to part 3 of the book. And as Gladys already said earlier, we have the pleasure here today to have actually 2 of the chapter authors present on chapters that relate very much to the issue of protection tools and how do they work, and how does this all relate also to power structures to some extent in the international system, but also between workers and employers, obviously. And I have the pleasure to give the floor to our colleague Natalia Popova, who will enlighten us a little bit on the issue of migration policy making, and the issue of what's the role of the social partners in there, and why should there be policy cohesion between this field and other policy fields. Natalia, thank you.
Thank you very much. I don't know why I'm starting from my last slide. So okay, so let's see. Okay, just 1 second. I think I'll need some help here because...
Where is your mouse?
I don't know, it has disappeared.
This is very sophisticated.
Do you need a mouse?
There. So use this.
What do I use?
Yeah.
but again, it's not working.
Yeah.
Yeah, I will need Alessandro's help, I think.
We will make it. It's an issue with the mouse. Here, okay, we make it. There you go.
Okay, so basically in my chapter, I'm looking at how labor migration policies are interacting with other related policy domains, mainly education and training, employment policies, and then how key actors, in particular the social partners, are involved in the different phases of labor migration policy making. And of course, the focus is on temporary labor migration. I mean, I see temporary labor migration as a subset of labor migration policies. Okay, so a little bit about the context. When it comes to labor migration governance, what we see is that this is a context, a policy context, which is rather fragmented. Labor migration policies are very much designed in silos, vis-a-vis education and training or employment policies. And this is true not just for origin, but also very much for destination countries. When it comes to temporary labor migration, more specifically, often we see that policies are designed as a sort of immediate solution to some emerging gaps, skill gaps, rather than taking a more longer-term perspective and looking at the structural demands of the labor market, in particular looking at, for example, demographic trends or technological transitions. So it's also often, as I said, immediate ad hoc solutions to address labor market gaps. Then temporary labor migration often covers low and medium skilled workers. So perhaps when it comes to highly skilled migration, let's say they are more established long-term regular pathways. But as I said, since this solutions tend to be rather ad hoc, low and let's say medium skilled migrant workers, let's say have a lot more limited opportunities, even when it comes to temporary regular pathways. Now, what are some of the key challenges when it comes to the design of temporary labor migration policies? I mean, one key challenge, and I guess this is not going to be any surprise, is to say that we need more and better data in order to have evidence-based policy making. And in general, this is a challenge for labor migration, but when it comes to temporary labor migration, this is even more challenging. It is an issue of having conceptual and definitional frameworks in order to allow comparability of data. But also it is an issue of, let's say, having the right tools for data collection, which are also affordable for countries in order to collect such information on a regular basis. I mean, the ILO is working already in this area. There have been some pilot experiences in terms of including temporary labor migration into household surveys and labor force surveys in particular. But again, a lot more work needs to be done. Another area which lacks evidence is the issue of skills anticipation and forecasting. And while in origin countries, this could be particularly challenging, also due to large informal sectors. In destination countries, this is also a key issue, especially when it comes to labor migration and even more so temporary labor migration. While I was working on this chapter, I was also drawing on some work that we did together with the World Bank in the framework of NOMAD, where we look at some high income and some middle income destination countries and how they try to quantify demand for migrant labor. And for example, even though there are tools for regular, let's say, data collection on skill needs from employers, when it comes to low and medium skilled sectors where we have, let's say, strong prevalence of migrant labor, like, for example, agriculture or the care sector, no data is being collected. So, of course, then this has an impact in terms of how destination countries design their migration policies and, I mean, the specific measures which they implement. So, I mean, this, as I said, particularly impact on low-skilled temporary labor migration. Now, I would like to focus now a little bit more on the skill side. So in many countries, the issue of skills matching and skills recognition is driven by labor migration. So the development of national qualification frameworks and in particular prior learning, which is, let's say, particularly pertinent in this discussion because we are talking mostly about low and medium skilled workers, so meaning vocational level of qualifications. A lot of this is done and, let's say, developed because of, let's say, labor migration concerns. Of course, this is a long-term and costly process. And often also what we observe, it is driven by the Ministry of Education. So when it comes to issues related to labor market relevance, I mean, both nationally and internationally, this remains rather challenging because the Ministry of Labor and employers and workers organizations are rarely being involved in this process. And as I said, perhaps for highly skilled workers, this is a little bit easier in the sense that also there are certain international agreements which facilitates at sector level qualification recognition. But when it comes to vocational level qualifications, this is particularly challenging. Now, what are some of the tools or, let's say, policy measures which could be implemented? I mean, one very popular one is related to bilateral agreements and the inclusion of skill components in such agreements. What we see again when it comes to temporary migration and low-skilled workers is that skill issues in general are very rarely included. Then another, let's say, issue is that in the process of design of these agreements, but also when, let's say, they are implemented and monitored, employers and workers' organizations are also rarely involved. So there is a lot of need of capacity building for the social partners to engage in this process and also to understand what is at stake for them and how they could contribute in an active way to the design of such schemes and more specifically focusing on low and medium level of skills. Now, perhaps what is also important to say here is that social partners, when it comes also to the design of education and training system, are very rarely engaged. And one of the main challenges when it comes to the implementation of bilateral agreements, or sometimes they also take the form of skilled partnerships, which are particularly in vogue these days, you would see that there is, I mean, some of, let's say, the main impediments to implementation is the employers communicating their skill needs to to the countries of origin, and then having a possibility for the migrant workers to be trained and then go abroad in a regular way. And this is particularly challenging for low-skilled workers. And in addition to this, let's say, communication issue, there is the issue of cost. So who pays for recognition for low-skilled workers? It might seem obvious, however, if you look at existing agreements, very rarely, I think we did some time ago a review of around 150 agreements covering low-skilled migration. Only 10 of them actually refer to skill matching and skill recognition processes. So very rarely this is taken up when it comes to concrete implementation. Okay, so this is my last slide. So I think there are two, kind of key points that I'm trying to make, and I would like to leave you with. I mean, one is that when we talk about labor migration policy design and also implementation of specific tools, such as, let's say, bilateral agreements or skills partnerships, there is a lot of focus on the technicalities of how skills are being matched, how they're being recognized, how skills could be harmonized along specific migration corridors. But somehow this discourse is disconnected from the issue of protection. And I mean, yes, migrant worker skills needs to be recognized and properly matched. But at the same time, the issue of how migrant workers could be better protected is not taken together with the issue of skills matching. And again, as I said, I mean, this is particularly relevant for vocational level of skills for low and medium skilled migrant workers in the context of temporary labor migration. And I think related to this issue is the issue of stakeholder engagement. From one side, it's easy to say, well, you know, just policies need to be better coordinated. There is like an emerging strand of literature looking at the more critical way at policy coherence. And I think one of the issues that are emerging issues and also perhaps potential solutions is precisely the issue of participatory approach. So how we can have key stakeholders, and in this case, the social partners, is, let's say, the real actors in the world of work, better engage at all stages of the migration policy cycle in order to, have better skills, but also better protection. So this is how I'm going to end my presentation. Thank you.
Thank you very much, Natalia. And I'm also taking away from your presentation the very interesting aspect how migration concerns influence policy in other areas, and the aspect of cross-fertilization between policy areas and the embeddedness of migration policy, all aspects that we highlight very much in the ILO all the time. So on the protection side, we are now moving to Daniel Costa, who is joining us from California. So from my perspective, this would be a deep sleep phase in which he has to talk to us now. Thank you very much for being here despite this early hour for you. And please fire away, Daniel.
Thank you. And it's a real pleasure to be on. And first of all, I just want to say thank you to the ILO and to Christiana and Fabiola for doing this book and for inviting me. It's a real honor to be part of this. So I'm going to try to share my screen here. Not sure if I'm going to be able to do it because I don't know how to use.
If not, Alessandro could do the slides for you. If you prefer.
I think that might be great. I'm in the share thing here, but it won't let me choose. So yeah, that'd be great. All right, great. Thanks so much. And I'm going to set a timer here so that I don't go for too long. So I think I would be negligent to not start off by just saying that in the United States, we are seeing radical changes to our immigration system at the moment with the current administration, and really workers of every type of status and workers without status are being impacted, and their rights are really under threat at the moment. Could you go to the next slide, please? And so, all you have to do is look at any newspaper, and most of the headlines on the front page are mostly about what's happening on immigration, and really the attacks on migrant worker rights and migrant families in general. And so I'm going to start off by just giving a little background on where the temporary labor migration programs fit in within the general U.S. immigration system. This chart here shows, and it's figure 1 from the book in my chapter, and it shows the number of new work visas issued in the different programs. I'll refer to these as temporary labor migration programs or temporary work visa programs, but I think I use the words interchangeably. And you really see an almost exponential increase in the number of visas, so new visas issued, new workers and families. And the increase has happened through both Democratic and Republican administrations, even during the first Trump administration, where work visas really did increase. The only dip that you find is around the beginning of the COVID-19 pandemic, where really bureaucratic slowdowns and shutdowns led to the numbers dropping in terms of new workers. And if you go to the next slide, please. That roughly 1.8 million new visas issued in 2023 does not account for the entire number of workers who are in the country. And unfortunately, the U.S. government doesn't have an official estimate, but because people can stay longer, the actual number of workers is larger. I've put together an estimate. In 2019, it was almost 2.1 million workers on who were in the U.S. on some sort of temporary work visa. That's about 1.5% of the total U.S. labor market. And the numbers in 2019, right before the pandemic, had actually increased by about 13% as compared to the last year of the Obama administration. So you saw during the first Trump administration, you really saw a crackdown on a number of immigration pathways, at least the ones that led to a green card or permanent residence and full integration into U.S. life. But when it came to work visas, there was really no sort of corresponding crackdown. Next slide, please. What my chapter focuses on is, one of the main solutions that's been proposed for really improving conditions in temporary work visa programs. One of the main flaws, and there are other flaws, and which I've written about a lot, but the main one is that it's usually thought of as the fact that people cannot change jobs easily to another employer. They are in effect indentured to their employer because employers own and control the visa status. They own and control the ability of a worker to be in the country, and they decide where that worker is going to be located, what their occupation is going to be, and what they're going to be paid. And so people across the spectrum in terms of opinions on temporary work visa programs have really offered up portability as the real solution. And portability, by portability, I mean being able to change jobs, being able to switch employers, whether that's because you find a better job or because your employer is abusive and breaking the law. And so you've got a couple of quotes here from well-known people. Vivek Wadhwa is a former tech CEO and well-known tech analyst. He says, "Untether the visa from the employer, and the free market will essentially fix all the conditions." Michael Clemens is a well-known development economist. He's said something similar, that being able to change jobs is a critical protection that will ensure that the law is complied with. And then Alex Narasti from the Cato Institute, which is sort of a corporate extremist libertarian think tank, has said that visa portability will allow workers to regulate their own environment and change it at will. And the kind of the takeaway you get from what people are saying is that if workers can change jobs, you really don't need more labor enforcement because that'll take care of everything. But, we do know from, just looking at low-wage industries in the United States, U.S. workers are able to change jobs, but that has not significantly improved conditions in low-wage occupations. Next slide, please. And so changing employers offered as a main solution, but does portability, in effect, lead to decent work? Does it lead to workers having human and labor rights? I challenge that premise in the chapter, and I think it's important to do this because temporary labor migration, just given political makeup in the United States, really is here to stay. There's no appetite for more permanent immigration with the current makeup in Congress, so it's really important to get these governance structures right. And I do think I should say that the book is really timely because I do think that we're going to see a lot of policy action on temporary work visa programs in the United States right after Congress passes a new legislative package that they're working on that will inject tens of billions of dollars into the immigration enforcement system, which will create pressure for more work visas. Next slide, please. And so there haven't been a lot of attempts to measure the impact of portability through research. I hope more researchers will focus on this, but we do know that workers who have visas in the United States often earn lower wages than similarly situated U.S. workers. And we also know that there are studies showing that people who move from a temporary visa to a permanent status actually earn higher wages when they move. Next slide, please. And there's some research showing that when workers change jobs, their wages can increase, and there's some research showing that workers who can change jobs, do suffer or have lower rates of being victims of crimes. Next slide, please. And so the substance of the chapter, which I'll try to sum up here, is just that in the U.S. it's not true that workers can't change jobs in all of these visas, but there is a spectrum of portability depending on the type of program. And so there are some programs that have limited portability, which means there's portability on paper, but it's difficult in practice. And these are some of the more lower wage visas like H-2A and H-2B. And then there's some programs that have some portability, but there are middlemen involved, and that makes it difficult in practice because those middlemen have to kind of sign off on the job changing. And these are programs like cultural exchange programs, what's known as working holiday makers in Australia, as well as people who are recent graduates of U.S. universities. And then there are some programs, a couple of programs that have near total portability. And even in these programs, it's fairly easy to change jobs, but there's some bureaucracy, and it has not really improved conditions in those programs. So the chapter gives lots of examples, really goes into detail into how portability works in practice, and the kind of thing I want you to take away from is that violations and abuses are still common, even despite recent policy changes. If you could skip ahead a few, maybe one more, another one. I'm just going to jump through for time. Another one, another one, another one, one more. Actually, another one. I'm so sorry. So the TN visa, this is the visa that has the most portability. But there's really no worker protections. There's no Labor Department enforcement or oversight. Next slide, please. And you still have cases where workers have been recruited to work as veterinarians, but they end up shoveling manure and milking cows, literally, and that shows that changing jobs hasn't really fixed the program. So next slide, please. So just want to leave you with the thought that portability is really not enough. It's the bare minimum for a program that's consistent with basic human and labor rights. And the governance frameworks still leave a lot to be desired. Next slide, please. So some of the major changes that you need are really to improve the program rules, better wages, more transparency, and especially a quick path to permanent residence that a worker controls. You need new protections from retaliation from migrant workers, and you got to dedicate more funding to labor standards enforcement. And next slide, and I'm going over time, so I'm just going to wrap up with this. The labor standards enforcement that really undergirds worker protections in the United States and that should be there as a backstop for temporary migrant workers. We spend almost nothing on it compared to what we spend on immigration enforcement. We spend 14 times more on immigration enforcement than we do on labor standards enforcement. And the worker protection agencies are really underfunded and understaffed. Their staffing and their funding has either declined or been flat since 2006. And so last slide, and I won't really talk about it. I was going to talk a little bit about some of the recent developments under the Trump era, but I can talk about it in the Q&A if necessary, and I'll just end there. And thanks again.
Thank you so much, Daniel, for the conciseness. And yes, we will look forward to also hearing some more in the Q&A session. And for time's sake, I will move immediately to the fourth part of the book. And our representative here is our colleague, Aurelia Segatti. Thank you, Aurelia, for being here. And I'll give you the floor immediately for some change of region, sort of looking at the migration regime between North Africa and Europe. Thank you, Aurelia.
Thank you very much, Christiane. Can everyone hear me well? Yes?
Yes.
Okay. So thanks a lot for organizing this. Thanks to Gladys for her introduction. I will try to speak to some aspects of the chapter, but perhaps to get started, I'd like to say that this chapter very much stems from the idea, tries to speak to some of the questions raised by Fabiola in her introduction, in particular this tension between the principles of social justice on one hand and temporary labor migration regimes on the other, and whether these are irreconcilable, sets of, frameworks. And I guess it's also from the idea that we have in the North African European context one of the longest experience in terms of temporary labor migration schemes in history, but with a lot of specificities, particularly when it comes to social protection. And I guess that's what I found really interesting in terms of analyzing this context over the longer term, and hence the title, Historical Legacies and Future Dilemmas. If we can move to the next slide, please. So I'll speak about, I'll provide an introduction, speak about some of the aspects of the chapter, particularly in terms of the European labor market needs and trends in North Africa, protection measures and future prospects, and I'll provide some of the key conclusions in the chapter. Next slide, please. So the chapter starts with the observation that there's a surge in demand for low-skilled labor in the European context, which is driven primarily by the European Union's need for workers, even though the situation may vary hugely from European member state to European member state, but essentially in the agriculture, tourism, hospitality, and non-medical care sectors. The chapter very briefly provides an overview of historical patterns between these two regions and how labor migration between the two regions has been shaped by bilateral labor agreements and by social security agreements, but how there are very significant challenges in terms of decent work deficits with continued concentration of North African migrant workers in difficult, dirty, dangerous, the 3 Ds that we know very well of until today. What I was interested in is to really envisage the consequences of this new surge, basically, which I situate around the end of the years 2000s, beginning of the 2010s, in terms of socioeconomic future of households and policy implications, particularly for countries of origin. And one of the first indications is that there's very limited recognition of the long-term consequences by both sending and receiving governments, and therefore a need to envisage much more comprehensively beyond the mere safety of workers, which is of course something very important, but to adopt an approach and an understanding that is more comprehensive of a full fair recruitment approach and even beyond that. Three key variables are found to be shaping this current temporary labor migration context between the two regions. Firstly, that labor demand from the European private sector it shapes this context, and it's important to be considered in the broader context of global value chains. Secondly, the migration policy fluctuations among EU member states are another important variable. And thirdly, the diplomatic strategies of North African countries in managing migration flows and the degree to which also these are tied to or at least take into consideration North African countries' employment and skills development policies. Next slide, please. So the chapter argues that while migration has re-emerged as a strategic approach to employment management, on the side of the EU in terms of labor sourcing, on the side of North African countries in terms of unemployment alleviation and part of broader employment strategies, there is still largely insufficient attention paid to both workers' protection on one hand and long-term social impact on the other, and even more so in terms of the second dimension. The chapter is structured around four different sections. Firstly, analyzing the European labour market needs, particularly France, Spain, and Italy. Secondly, providing an overview of the flows from North Africa, so more of the North African structural dimensions. Thirdly, assessing the measures implemented by both EU and North African governments to prevent migrant worker abuse. And this is more about what Fabiola was saying about not everything is gloomy, and we have some prospects in terms of policy change and in terms of operational mechanisms in place. And finally, evaluating existing socioeconomic mechanisms in place for North African temporary migrant workers and their families. And there's a specific focus on social protection. Next slide, please. So in terms of the European labour market needs, I may certainly be repeating things that some of you know very, very well, but the chapter explores and provides some statistics on Europe's declining demographic and labour shortages in certain sectors and occupations. The member states have increasingly restricted long-term immigration, but interestingly, temporary labor migration schemes have been on the increase since the beginning of the years 2010s, with new agreements or the revival of former agreements between Spain and Morocco, for instance, between Italy and Tunisia, or France and Morocco, as well as completely new agreements signed recently between Greece and Egypt, or even more recently between Mauritania and Spain. The chapter spends some time in this section on unpacking the so-called triple win narrative and circular migration, and making reference to the literature that's available on this. But essentially to point to the main paradox which the two regions currently face, which is that on the one hand, there is a situation of declining demographics and projected needs, which are acknowledged in research, including by the main European research institutions. But on the other hand, increasing political hostility and xenophobic stance that we all know very well from right-wing governance in European member states, as well as very conservative positions in terms of brain drain in some North African countries. And this, comes as a very, as a tension, which very often is not reflected as such in the media, with an overemphasis on still on migration as a security issue. Adding to, if you add to this the fact that figures are likely to be vastly underestimated due to the scale of undeclared labor, you have a situation which at the moment continues to be dominated by this Ministry of Home Affairs, Homeland Security, etc. Perspective, whereas there is currently a lot of activity happening in terms of ensuring facilitated labor sourcing for European member states. Next slide, please. So in the next section, I try to explore the protection measures and future prospects. As I said, numerous protection gaps persist in all recipient countries. And this is as a result of most measures focusing on formally recruited workers, whereas, as indicated, there continues to be large numbers of undocumented irregular workers, which fall completely out of protection mechanisms, except if you take into consideration policing measures, of course, with Europol and Interpol in terms of fighting against forced labor and trafficking, or in terms of return and deportation measures at times. On the more positive side of things, current efforts include the strengthening of public employment services in a number of North African countries, and that's something, of course, that the ILO supports. In terms of their capacity, in terms of their internal development, with the professionalization of international placement services, in terms of more transparency in recruitment processes, and in terms of something that's perhaps even more innovative, which is accompanying measures in terms of return and socioeconomic reintegration, and that's something we are currently supporting with the Moroccan Public Employment Service, ANAPEC. The regulation of private employment agencies is also something that is very much currently being researched in terms of ecosystems, in terms of business models, in terms of also the development of new legislation, as in Tunisia, for instance, as well as in terms of implementation of Convention 181, where it is adopted or considered to be adopted. There's also initiatives in terms of bilateral and EU level initiatives, multilateral initiatives, such as the talent partnerships, bilateral agreements. But I would completely agree with Natalia previously that there's a lot of emphasis there on skills development, skills matching, certification, recognition of qualification, and this is very often disconnected from protection. And finally, in terms of social protection, there's there too quite a bit of research happening, especially research on the actual access to benefits and the implementation of new measures to facilitate the reality of access. And this is something that also ILO, through different projects, but in particular Templus, is supporting in North Africa, and where we have quite positive prospects. Next slide, please. So in terms of the longer term, prospects and what we can say, the key challenges which need to be taken into consideration are the lack of these sustainable reintegration programs. We have one example, one pilot being run in Morocco, but that's pretty much it for the whole of North Africa. There is this whole question of economic instability of migrant households involved in temporary labor migration, and the question of what would be the mechanisms for an actual way out of the cycle of dependency on seasonal migration, because we are speaking, for instance, in certain schemes of people who are repeat temporary labor migration workers for sometimes as long as 14, 15 years. Gender-specific barriers, which I do not have time to envisage here, but which are very present, particularly, for instance, between Morocco and Spain for women migrant workers. And finally, social protection gaps, which I've already mentioned, but where there are some very well identified gaps and challenges, but also solutions, potential solutions that we can work on, and some of which, such as digitalization, for instance, simplification of measures, or better, coordination between existing systems on the European side and on the North African countries side, which we are currently exploring. These recent efforts include available research conducted by the European Trade Union Institute, as well as this pilot project Wafira, which I was mentioning with ANAPEC in Morocco. Next slide, and final slide. So to conclude, the chapter reaches 4 key conclusions, but of course, which would be worth exploring further in future research. Firstly, that like the other speakers indicated, labor migration and temporary labor migration in particular is here to stay. It's a very long-term trend. But the interesting situation is that despite political opposition in some EU countries, the current demographic and labor market trends and needs will continue to drive demand for North African seasonal workers and will continue to make offer available on the North African side of things. I identify in the chapter 3 channels of temporary labor migration, which coexist and which would be worth continuing to study: formal schemes, private sector initiatives which straddle the legal, formal, informal, in many different ways, and the completely illicit underground recruitment networks. Thirdly, investment in regular migration pathways and reintegration programs is largely insufficient, but these are definitely the way to go. And protection measures should also be strengthened through trade union agreements, improved public employment services, better regulation of private recruitment agencies, and structured reintegration support. And we now have enough material to say what works and what would be operational solutions to put in place. And finally, in terms of social security, there's a real need to build on all the lessons and all the know-how that there already is in terms of bilateral social security agreements. They need to be expanded, reinforced. Digitalization, awareness campaign, institutional cooperation, twinning of services, etc., are measures which currently need to be beefed up and expanded and accelerated. And I hope we'll have the opportunity as ILO to support the implementation of some of this. Thank you.
Thank you so much, Aurelia, for this comprehensive overview and giving us plenty of ideas of where we should work on in future and where you already have started in your region. Are there any questions in the room or outside of the room? Yes, Adele, please.
Ben voilà. Okay, thank you very much. So I'll just repeat, thank you for the very compelling presentations. I learned a lot. And the sign of the time, it's hard to listen to the presentations without, of course, thinking about this moment. Presenter from Danny alluded to this. And I have to say, when I heard you speaking about portability, but it was literally about workers being bound to an employer. I thought, this is really a sign of where we are. And several speakers, including the last, spoke to the issue of social protection and how it might become portable in the way that we used to think about that, partly through bilateral arrangements. But I'm really grasping for the spaces that are still open for thinking multilaterally about social protection, and in particular, what policy conclusions might come out of your work or your ongoing reflections around where we can foster the kind of connection. So, all of the wonderful suggestions that were made around the bilateral social security, what is the role for thinking about how we move those up and out more? And as I say this, I think about the fact that migrants don't just go in a circular fashion between two countries, their home and host countries, but increasingly we know the patterns move them through many geographical spaces. And so if we're not, we're certainly, and your work really powerfully critiques temporary migration. I'm grateful for that. But if it is very much a part of the now in this landscape, how do we move us to a place where we're also very carefully building the kind of architecture that makes social protection a longer term reality? And I don't want to continue, but I do think the point that was made about the relationship to labor law and labor conditions is so crucial. And then the parallel is not so different either, right? Our incapacity, in other words, to build in the kind of safety nets that then allow workers to move, be it across borders or within jobs in the same city, are very much there. So the ask is really how do we think transnationally through this?
Thank you very much. We'll come to that. I see that Richard wanted to make a comment or has a question.
No, thank you, Christiane. I just had a reflection stemming from Danielle's presentation on portability. Of course, we're talking here about changing employers, right? And moving away from employer-tied sort of visa systems. And of course, this resonates very strongly, I think, with a focus in the Arab states and the Middle East on addressing, the kafala sponsorship system, which is, a form of an employer-tied visa system with its specificities. And the reflection here, and I think your contribution is really important because, Natalia in her presentation talked about, labor migration policies often designed in silos. And to draw on that, I think we really need to exercise a lot of caution when we talk about, various protections that are needed for workers in the context of temporary labor migration programs, that we don't kind of overly focus on certain things, like changing employers, or, for example, even in the context of migration, also fair recruitment, right? Fair recruitment is important, but it is not a panacea for decent work. Or even those that are recruited fairly and not pay fees and so on, we need to look at more sort of bread and butter labor market protections relating to wages, occupational safety and health. And I think another aspect which is key here and is often seen as an important enabling right is the right to freedom of association and to organize, which often is denied or restricted significantly. And clearly, this is the case in the region where I'm in when it comes to temporary migrant workers. So I just wanted to give that reflection because clearly a holistic approach and assessment of these issues is really key, I think. So I think your presentation, Danielle, in that context is, draws attention to this issue. Thank you.
Thank you, Rajard. And if I could just try to, I guess, in the interest of time, try to make a couple comments in response to the questioner, who I apologize I didn't catch their name. I think that multilateral solutions, at least from the U.S. perspective, are going to be quite difficult. The current administration does not believe in multilateralism and is looking at pulling out of numerous treaties and international organizations. When it comes to the sort of portability of kind of social security type benefits, the U.S. does have a number of they're called totalization agreements with other countries, so that kind of social security type retirement funds can be shared. India in particular, this has been a top priority for them for a long time, because 3/4 of the 600,000 H-1B temporary migrant workers in the U.S. are Indian nationals. So that can be done, but that's also at the bilateral level, and so that's complicated from the reality that people go to different countries. But we do see in the United States, at least, many workers who return for 10, 15, even 20 years at a time, and are really separated from their families and aren't able to stay. But I think it would at least benefit those workers if there was more of those types of agreements in place. And then when it comes to really creating more and better protections in the United States, it would not be that difficult. Obviously, in the U.S., passing laws through Congress is very difficult. It doesn't happen very often, and passing laws that benefit workers is even more rare. But the reality is, many of these programs, there's a lot of executive authority, a lot of authority in the administrative sort of system to create new worker protections for these programs. And during the Biden administration, there was a lot of advocacy to improve protections for temporary migrant workers. There were some improvements that are real, but the danger of that is, of course, that the Trump administration can pull back on those and get rid of them almost at will. And then last thing you mentioned was the labor enforcement. Without real labor standards enforcement that workers can access, it's really impossible to believe that these programs will ever be consistent with human and labor rights. And we've only seen labor enforcement go in the wrong direction. Right now, I think there's 650 wage and hour division investigators at the Labor Department. That's 650 people who were in charge of policing a labor market of 165 million people. And that's a record low going back to all the years that we have data for, going back to like the late 70s. And so it's a really challenging time for migrant workers, and especially with work visa programs. And we've seen President Trump just in the past couple of weeks say that many of the workers who are being deported and who are losing status are going to be allowed to come back, but come back through pathways that employers control. So we're going to see, migrant workers in the United States are almost 1 in 5 workers at this point. And so they're the backbone of many industries. So they're not going anywhere, but they're just going to be shifted into more precarious statuses that employers control, unfortunately.
Thank you so much, Daniel. And I see that Samia would like to react as well.
I don't know if you can hear me. Can you hear me?
Yes, fine. Thank you.
Okay. Thank you. Thank you, Christian, and thank you, colleagues. And I'm really sorry for joining late. I was actually in a parallel panel which was talking about social security agreements with the International Social Security Association. And I just arrived when the question on multilateral agreements was raised, and I think this is definitely a key issue. Many countries in different regions have actually concluded multilateral social security agreements. If we look at latest ISAF figures, we have over 660 agreements being implemented, bilateral and multilateral. And in some regions which are actually promoting the free movement of labor, such as Africa, there are many multilateral agreements which are being designed or are currently being designed, but there are some implementation challenges. As was mentioned, I think, by Aurelia, it's definitely a key instrument if we want to ensure the portability of social security benefits across countries. But it's not sufficient in a way. You also need to make sure that the social protection systems are inclusive of migrant workers, that the principle of equality of treatment is enshrined in the national social security law. And this is an important challenge that we need to continue to promote. And also mentioned by Aurelia, there are, in some cases, agreements in place, but then you can have institutional capacities which are lacking to implement them. And this whole issue of digitalization is really important to ensure data exchange. And hopefully with this digitalization that is starting, we will have more, I would say, improved implementation of such agreements and in the future. I just wanted to flag that. And we have on our website that I can share the link, a number of tools that we have developed to support our constituents in developing such agreements together with the International Social Security Association. So I'll share the link. Thank you.
Thank you so much, Samia, for that very lovely answer in a very comprehensive way. I think we are on time and no more time to wrap up, I suppose. We still would have plenty of questions to all of you, but we will have to post them at another time. Is there anyone who still feels an urgent ink to have a last remark or a last question?
Okay.
Yes, there's one more in the room. And I'm sorry, I don't know your name.
That's okay. My name is Ekwemi Namoko. I'm with the Norms Department, Equality and Migrant Workers Unit. I do have a question about part 3, specifically for Sophia, but I don't think she's here at in the meeting. It's more regarding in the context of this work. It's been, there's been arguments in favor of bilateral labor agreements, and in the African context, it's also been mentioned. My question is, to what extent, considering that there's, and also that speaks a bit to what Adele said earlier, considering that the majority of migration in the African region, which she has referenced and used as a sort of case study, it's mostly intra-regional. To what extent has regional cooperation or regional communities been engaged in terms of looking at this temporary labor migration and social justice promotion? Another aspect, or well, maybe different sides of the same coin, is the extent of gender-specific interventions in the context of temporary labor migration, and how does the ILO promote that kind of balance? Because there has been academic arguments that perhaps bilateral labor agreements do not necessarily address gender-specific issues in the low-skilled migration space, and so that's just 2 questions. Sorry if there's no time to answer it, but I'm happy to keep following this conversation. Thank you.
Yes, I think some of this would actually be answered in a background report that we have produced for the discussion of the governing body in November 22. So since we are at the end of the seminar, we can come to you individually and discuss a bit. But we would also like to highlight that big report exists where some of the aspects that you raise are being answered. And with this, I would like to thank you all for being here. Thank you for all the support, also from our colleague Alexandro and Manuel, without which this would not have been possible technically, and probably none of you would have heard about the meeting here. Thank you for the ILO colleagues who have been here, who have worked on the chapters. Thank you for our external friends from our network of experts on temporary labor migration. Thank you. It was absolutely lovely to work with you on this book and also to have you here. And every time you intervene, we learn something new. So many, many thanks. And with this, I close the meeting. Thank you.
Thank you. Thank you.
Thank you.
We'll continue the work. There's a lot of questions
Thank you very
raised,
much.
so lots of work to do.